Era ser essa boa. And the problem is that this issue is necessary because you were that they don't want to come. Disrupt this chain.
No. But what is no. I don't want to put it. Because one has to be taught on our board. It's not easy. Papa, back in my house. I thought I'm not going to say that. Marwana was on a back. So it's not easy. High profile people. The dealer I don't make that much. You know what they do? What are the end users? They Cuba, 25% of the original manpower. I think it's 100%. Supply shower now, I don't have religions. Some other stuff. I don't really know. Because when I go where someone take condition for we think it's a condition and the time we did them who are tough, I think they use Brazil 80%. All of so that is the one that was the mine. If it's in a 500,000, you don't make it so hard to get a thing. You don't know what is going on. Unahanurala monga mix and mix and bring on I don't know whether Nigerians or but to know it and open because the open is developed in South Africa.
Yeah, the original open is from South Africa. We don't know
how they just make a lot of things. I recall the matter A799. Worship, Siemens Counsel for accused present.
Mr. Jamal Diaz indicated English. Mr. Kusani, to confirm that you are
Indeed, Sir, Your Worship, I do confirm that I am on behalf of the accused person, my client, and I seek the court leave worship to approach my client. Court business, Worship. I just wanted to confirm, Worship, one thing. My client will proceed in English.
Mr. Kusani, before we adjourn, I'm glad that you are also representing this particular accused.
Court business.
The issue of media houses. We have dealt with the application previously.
Yes.
Do you have instructions that are otherwise?
Your Worship, I'm under the impression or understanding that the media houses will perhaps have to make an application in respect of accused number 2. But Your Worship, seeing that he is accused number 2, there is accused number 1, for the purpose of simplicity, I will not oppose to the media houses that would be making an application to partake in this criminal proceedings issue. So it will be a fruitless exercise if I jump and say no to them in participation of.
So we are unable again that same ruling was granted in respect of accused number 1 should be applicable.
Yes, Worship, should be applicable, Worship, yes.
So I don't see Mr. Where is Mr. Kusinaji?
Yes, I do.
Mr. Minister, we had the defense.
Yes, indeed.
Application is not opposed. Just briefly state the nature of the application for record purposes.
Indeed, Your Worship, thank you very much for the indulgence, and we're just going to be a whole lot quicker than we were the last time. On the issue of public interest, given that this is a very serious case and we're seeing it unfold, especially as it pertains to the investigation by the South African Police Service, it's a matter well documented where we speak of the killings of police officers and some of the circumstances that give rise when we look at this particular community, in that it is well known for gang violence. In no way, Your Worship, are we dealing here with the merits of the case, but we thought it's important to give context in terms of this application, in terms of the seriousness of the nature of the allegations brought forward by the state and the circumstances thereof in arguing for public interest. We also then want to emphasize that our application and our rights as the media and the public cannot trump the accused's rights to a fair trial, and want to belabor the point that the accused is presumed innocent until there is then a final determination by the Honourable Court, also arguing on the basis of open justice that the public and media once again have constitutional rights to access and report on proceedings. Ours is to respond to that call to duty by the public to relay and inform them. And of course, once again, want to refer to the fundamental case of Breeder versus Media 24, where the court essentially cautioned, that's the Supreme Court of Appeal, against a blanket approach in terms of restricting media access, but of course said that in terms of the restrictions, they require a real demonstrable and substantial risk of prejudice and not mere speculation. And also said that they can then be the safeguards which we argue to protect the proceedings of the court. Just as we wrap up in terms of just giving a sense of this nature of this application, Your Worship, we want to emphasize once again our role, but once again we are at the hands of the court, and our prayer really is that the court will once again find in our favor, especially given that there is no opposition from the defense, and we will abide by whatever restrictions will then be outlined by the court. We have also then supplemented our application with adding additional paperwork in terms of the applications themselves, Your Worship, and we hope that the Honourable Court has received these applications.
Your Worship, as I've already alluded, Your Worship, that we are not opposed that the media houses partake in these criminal proceedings, Your Worship, and I will request that the court ruling, Your Worship, that was rendered by the court itself should prevail, and we shall abide ourselves by it, Your Worship. And that will be the response, Your Worship, from us.
Any input, Council, from the state?
As we previously said, we abide by the court's ruling.
First appearance of accused number 1 was on the 12th of August 2026, and there was an application, an interlocutory application by the media houses, and the court has pronounced a ruling on that application. Same conditions and are applicable in this one. Therefore, application is granted.
Your Worship, may I then request the matter to be postponed to the 25th of this month for this accused to be formally joined. Actually, it's joined, but just to appear together with accused number 1.
Mr. Kuzari?
Yes, Your Worship, before I confirm whether the date suits my client, I find it of paramount importance to deal with the provision of Section 60, subsection 1, subsection 11, Your Worship, paragraph B. My client, Your Worship, before this Honorable Court does not have any previous convictions, and he does not have any criminal pending cases. This is his first criminal case. And furthermore, Your Worship, there is no warrant of arrest issued or outstanding against my client, and there is no protection order against my client, Your Worship. And Your Worship, my instructions in respect of accused number 2 is to bring bail application on his behalf. And we will therefore, Your Worship, request or rather confirm that 25th of August 2026 is the suitable date for bail hearing, Your Worship. And I have no further submissions, Your Worship, not unless the court has questions. Court pleases. And Your Worship, if I'm sorry, Your Worship, to interject, may I approach the accused person, Your Worship? God pleases. Thanks for calling, Judge Bishop. Nothing further.
Counsel for the state, where is the accused detained?
We want to avoid the unnecessary drama. The J7 can be endorsed as normal. I understand that normally it is endorsed Boksburg.
Now that you've said that, Counsel, on the previous matter, you will correct me if I'm wrong. You will remember the matter of Mr. Collins been agreed about the date of the 25th of the defense, and the only submission you made was that accused in custody.
Yes.
No bail.
Yes.
And it was brought under my attention by the clerk of court that J7 either should be endorsed as Koshi Mambu or Modapi. I was reluctant to do that. Firstly, there was no request to make it or to name it as an application per se. However, provisions of section 339 of Act 51 of 1977 are simple. After first appearance of the accused, obviously that would be in terms of section 50, whether he is from the police cell or from prison. If we postpone the matter to a correctional center other than the correctional center that is used by the court, there must be an application or request so that the court endorsed in terms of the provisions of section 339 of Act 51 of 1977. That was not done previously. I've endorsed that J7 on request of the clerk of court, but it is an omission.
I concur.
Mr. Collins is supposed to be detained in Boksburg Correctional Center unless a proper request was made and reasons advanced as to the reason why any other center except Boksburg. Because detaining an accused to another correctional center is in terms of the application and the court endorsement, whether for security reasons or suspicions that he may escape or any other reason. But those reasons were not advanced to the court of request. So what are we doing with accused number one who is in Modapi in the absence of a formal request? Should I endorse a J7 in his absence that he is going to go to Boksburg prison, or we keep Modapi until the 25th?
I will submit that we keep Modapi as a prison, because when we discussed with counsel on the previous occasion, he did not have a problem with that. Hence that was done. And actually, at some point, we were summoned to the chambers, but later we informed that can be done without us approaching the court in chambers. That's what we were told. The defense was aware of what we intended to do, even though it was not done, as the court has just alluded now. It was not a formal request. But for purposes of this, let us keep him in Modapi. Then on the 25th, we'll do things as per procedure.
Yes, Ashok, if I may reply. Your Worship, the state is actually correct to say I was away. And they have approached me in respect of that. But Your Worship, looking at the procedure that must be followed and at the law itself, currently, Reiger Collins, accused number one, is not supposed to be detained in Modapi prison. Therefore, Your Worship, I will have one request, only one request, that my client be brought back within the jurisdiction of this court, which will be the Boksburg prison. We might have agreed outside court, we might have agreed extrajudicial outside court, but was it the procedure? The answer is no. And if the answer is no, it nullifies. It makes everything null and void. And it makes one to actually go back and follow the procedure. So, procedurally speaking and legally speaking, looking at the law, accused number 1 is not supposed to be detained at Mujabi prison. Is it? Actually, Your Worship, what was supposed to have happened is that the court, we were supposed to convene again and make the state make that application. And actually my client is very dismayed that he's detained in Mujabi prison. He's not happy with it. So I will request, Your Worship, this honorable court that rather, if practically possible, that be a J7 that says the accused number 1 should be detained in Boksburg prison, which is the prison within the jurisdiction of this honorable court. And what makes everything null and void is the fact that there is no explanation from the state. They have never alluded why he should be kept in Mujabi prison. It's even better if there were perhaps some speculation risk or speculative risk, so to speak. None whatsoever. So accused number 1 being detained at Mujabi prison, his detention there is null and void in law. Absolutely, without reservations. So, as I'm saying, Your Worship, there was supposed to have been a formal application dealt with by the court. So, with that being said, Your Worship, we then request that our client, accused number 1, and together with accused number 2, they must be detained in the prison that is within the jurisdiction of this court. And that prison is Boksburg prison. It's the prison that makes sense if one is arrested in the jurisdiction of Boksburg. That is the only prison. So that will be my request to court business. Not unless the court Your Worship has questions. I'm willing to answer them.
Irrespective of these informal arrangements that you yourself made with the state.
Yes, Your Worship. The nice thing about the law, Your Worship, is that there is always a remedy. And I'm not saying, no, I never partake in those arrangements. I am willing and openly saying, yes, I have. But let's look at the procedure. And let's look at the law. And the procedure is, together with the law, as they overlap, one must make a formal application in court. This is not a spoliation application, Your Worship, where one does it in chambers on urgent basis. No, it must be done in court.
And Mr. Kuzan, you are aware of that as early as the 12th of August, when you enter into this informal arrangement with the state.
Your Worship, I was aware after. The matter was postponed, and then after I was approached. The matter was postponed to the 25th of August. Later, the state approached me. The state approached me. Hence, Your Worship, I'm saying, this is not a matter that can be heard in chambers. This is not a spoliation application on urgent basis, where the court sits and make a decision. No, it was supposed to have been done in court, procedurally speaking. And you, actually, Your Worship, it's the fact that I was acutely aware does not make it valid in law. It doesn't. The fact that I, the defense legal practitioner, together with the state, we were aware of it, doesn't make it valid. It still remains null and void. Simple as that. So, because the moment that one is detained in a prison, in which there is no J7, which give explanation why he must be there, then the moment there is no justification into that, then everything falls away. Particularly in this case that it was done extrajudicial. It nullifies everything usually, literally. Yes, one may argue and say, no, the defense attorney was there to protect the accused person. But let's look at the procedure. Let's look at the law. Procedural speaking, accused number one is not supposed to be at Mutabe prison. It's not. Procedural. Which is why we have the court that actually is impartial to make a decision in respect of that. To safeguard anyone that makes error in law. So that is my argumentation.
I wouldn't regard it as an error in law. There was no application.
Court pleases you. Correctly put by court. There was no application at all. So the non-existence of the applications nullifies everything with immediate effects. So that will be all, Your Worship.
Counsel for the speech.
My Lord, may I be excused for now because my colleague was dealing with that matter on that particular day. He will be able to argue as to the reason and Ramchapedi will come.
And counsel, you don't address me as my lord.
Yeah, well, I understand. I think the court will understand why. As the court plays, Your Worship.
Well, it should be held in contempt, Your Worship. And he can explain for himself. Your Worship, as an officer of this court, I want to put things into perspective, succinctly for everyone in the House to understand. On that date, when we postponed the matter, everything was done in good faith up until when the matter was adjourned. These thorny issues that led to the J7 being amended to Modabi, they came after the court has adjourned. Otherwise, they would have been put before court while the court was in session. There are valid reasons why that request had to be made. It's just unfortunate that such reasons were not properly placed before court. But Section 339, is it 339? Yes, Your Worship, was specifically designed to protect the interest of an accused person, more so the unrepresented ones. I was very much worried when we got a call from my office that it appears we did something unethical. And I was very much at pain to explain that that was not the position. We were walking out of the courtroom when officers of the court approached us to say, there is an issue of a J7 which you did not resolve. And I was not aware what that was. Then I immediately approached the investigating team to say, what is that issue here? And then they informed me of certain things which I think it will be only proper to be ventilated once the current court order has lapsed. Because a J7 on its own, it's a court order. And it cannot be replaced unless a higher authority has to intervene, which is not the case here. Because what is endorsed by the court, it is a court order. There are very, very valid reasons, Your Worship, why that was done, and we will put across the very same application on the next court date upon the expiry of the current court order. It's not that it was done maliciously, because I did approach my colleague to say, there is this burning issue here. My investigating team are informing me of 1, 2, 3, 4, 5, 6. They are requesting that can the accused, instead of being taken to Boksburg prison, be taken to Modabi for the following reasons. It's just that we did it extracurricular. My colleague said to me, he's got no issues. He's not opposing that, and the accused will not suffer any prejudice because of what was put forward was the distances between his family, visitation rights, and so on. To say there won't be prejudice from the family if they want to visit him because the distances are the same. I am not familiar with the two correctional facilities, but that was what was informed to me extracurricularly. Then I informed the clerk, she is sitting here to say, This is the position. Is it possible to endorse the J7 for moderate? Because we are agreeing with the defense that this should be the position. Will there be a problem? Then the clerk told me there won't be a problem. I said, if there's no issue, issue a J7, take it to the magistrate for signature. Then that was the arrangement. And we left the court building. Then I was informed later that no, there's something which I think via the senior public prosecutor here, that there's something which was not done by your team correctly. It was an oversight. I can blame myself, I can blame my colleague. We are both equally guilty of this. There's no one who's clean here. The thing was that we agreed. There's nothing in law which prohibits the two consenting parties to come to an agreement of some sort. That is specifically designed to curtail issues. Unless that which is agreed upon, it's ab initio illegal. There's nothing illegal about what we did. It's just that the court was not privy to the reasons why this was done. But there are very, very, very valid reasons why this was done. There was nothing malicious about everything. The issue of prejudice, I discussed it with my colleague and we agreed. Otherwise, I was not going to entertain it. If he had already left the court building. I was with him on the corridor and I dragged him back into the court building. The initial arrangement was that we should reconvene the court. And I was informed it was not necessary because we are agreeing, we are not fighting about this. So the issue of prejudice was settled. That was the intention of the section. So currently there is an existing court order which says keep that person there for up to this specific date. When he comes on that day, because we cannot willy-nilly go and draw the court order and replace it with the other one. It's ultra vires. So what we have to do, when the court order lapses, we will bring a substantive application, which I think I don't even see my colleague objecting to that in essence. It will be just a procedural exercise. Those will be my submissions. Thank you.
I agree with you, Council, that up to the 25th
Indeed.
of August 2026, the J7 for Mutapi remains valid.
Indeed.
The issue of the emission will be dealt with on the next one.
Indeed. I'm indebted.
Are you coming back, Council? So the agreed date is the 25th.
The 25th.
Also for bail application in respect of accused 2.
Yes, Your Worship, I confirm for bail application in respect of accused number 2 and 1. May I kindly approach again, Your Worship?
Mr. Mayors, in terms of the provisions of section 157 subsection 1, you are joined with accused number 1. Your matter is remanded until 25 August 2026 for accused number 1 and formal bail application.
Yes, Your Worship, I just want to briefly make some submissions before the court. My client just instructed me that he was brutally assaulted by the police and he has a sharp pain on his chest. So therefore, Your Worship, I would request that the charge sheet be endorsed that he
Be kept in the medical
yes,
section.
Your Worship, until he feels better or he gets better.
I've got no objection. I'm just alarmed by the word brutal. If that was so, he shouldn't be stating it. But we don't have an objection. If he's feeling pain, it's his right to receive medical attention. Please, the
Well,
Please the court.
It may be brutal if it's intentional.
It is indeed so. For a lack of a better word, brutality is brutality.
Therefore, you are remanded 25 August 2026 for accused number 1 informal bail application. You will remain in custody, no bail, specifically stated in Boksburg prison. Your J7 will be endorsed that you be kept in the medical section or receive medical attention.
Call please, His Worship.
Please the court. I'm not sure what the court is with my colleague, the resident prosecutor. Arrangement will be made with him to come back. I don't think this one is finalized yet.
We are not even on half. You are excused.
Thanks, Worship. I sympathize.
Or should
We can adjourn?
Adjourn so that the
Yes, the media personnel can.
court adjourn.
The court is still sitting there.
One and only.
Next week.